They are not permissible under my watch.
It is interesting that he who begs for protection is the first one to throw the knife. He doesn't even try to get close enough, sir, to actually put the knife in my back, but he often tries to throw it across the well of this house at me. I continue, sir, because I am going to justify every single thing that I'm saying. Sir, to put him out of his misery, let's just go straight, sir.
Honourable Member for Christchurch, so please, I have just returned to this chamber. Things that you might have done in my absence cannot and will not be tolerated in my presence. But if you cannot act with civility, I will soon ask for you to be removed from this honorable chamber. I believe that you know better. Honorable Member, I know that you know better. Honorable Member, I know that you know better. I know that for a fact. You know the rules of this house. You know the standard orders of this house. If you do not wish to abide by them, I will then ask you not to enter this chamber if you do not intend to abide by the rules of this house. You know them. You are a mature person. You have been in this chamber since 2018. I expect better behavior from you, a seasoned, mature member of this parliament. Yeah, but honorable member Christchurch, so you cannot ask the honorable member Christchurch, but no, but you have not said that. You cannot ask the honorable member to say for Christchurch is to respond to you. Any protestation that you might have must come through this chair. Must have to come through this chair. And as I said before, you know the standing orders of this honorable chamber. And all I will say to you, abide by them before you are taken away from this chamber. That is all I will say to you. If you do not wish to abide by the standing orders, then don't enter this chamber. You know them. You know them. If you do not wish to abide by them, then do not enter the chamber. It is as simple as that.
With respect, Mr. Speaker, the Honourable Leader is misleading the House. I have said over and over, the Honourable Leader of the Opposition, when I refer to him the second time in the same sentence, I use him or he, which is his legitimate pronoun. If he wishes me to use another pronoun, then please let me know.
Honourable Member, continue. Please continue. Honourable Member, continue, please.
Sir, for the avoidance of all doubt, for the next 5 to 10 minutes until I indicate, sir, that I am moving off of the topic of the Honourable Leader of the Opposition, he can assume with the greatest of respect that any pronouns there given refer to the Honourable Leader of the Opposition. Sir, can I continue?
Continue, Honourable Member for Gracious.
Sir, the Honourable Leader of the Opposition pomposetted, carried on, lambasted the Honourable Attorney General on the basis that we have in this legislation pulled away a constitutional right, a common law right, the right to corroboration. Sir, obviously, the Honourable Leader of the Opposition has not availed himself of the opportunity to read Section 28 of the same Sexual Offences Act that we are now amending. So the existing and current section reads, subject to Section 31, where an accused is charged with an offence under this act, no corroboration is required for a conviction. It goes on to say, but the judge shall warn the jury that it may be unsafe to find the accused guilty in the absence of corroboration. It does not require corroboration. Sir, but that's not the first place it came. It is not that that happened to drop in to that piece of legislation. Sir, in Section 136 of the Evidence Act, 1994, as far back as 1994, corroboration was abolished. There is no requirement under the laws of Barbados as of today's date for corroboration in sexual offences trials. None. So I simply wish to point out that the Honourable Leader of the Opposition, perhaps, sir, due to, I don't even want to use the word ignorance in its purest term, ignorance being a lack of knowledge, but the Honourable Leader of the Opposition clearly is not even aware of the substantive act that we are coming here to amend. We have taken away no right. The Honourable Attorney General made the point that corroboration, the requirement for corroboration does not exist in our laws at all, under anything. It is not required for sexual offences, for murder, for nothing. It is not required at all. It not being required and not being required in most common law jurisdictions, it is a nonsense for a judge to turn around and warn a jury, you know what, this is not required, but it may not be safe to do it without it. We've taken nothing away from the defense of the accused person. His lawyer is perfectly in order, is perfectly entitled to when he is summing up, to when he's giving his closing, even during the cross-examination, to drop it, put it, address the jury and advise, you know what, there ain't no requirement for corroboration, but this is unsafe. This evidence does not reach a point that it is safe to convict this person. In this case, in these circumstances, quite frankly, it would have been best if somebody else could say something. It would have been best if we had DNA evidence to throw in it. It would have been best if something. It is not required now. What we have removed is the obligation by a judge to give a warning about the safety to convict in the absence of something that is actually not required. It is a legal nonsense, effectively. All we have done is to clean that one up. I am sorry if the Honourable Leader of the Opposition had a trial looming in which he planned to use the fact that there was no corroboration as the defense for his client. Well, I am just, sir, as a helpful, I mean, he is in the constituency next to me, as a helpful neighbor, and yes, he did invite my constituents to his camp, so I'm returning the favor and advising him that that limb on which he sought to rely doesn't actually even exist now. It didn't since 1993 or 1994. So I hope I have cleared that up entirely. Let me now, sir, go to the other thing that he harped on and hanged on. The Honourable Leader of the Opposition questioned the fact of the amendment, I believe it is to Section 3 of the Sexual Offences Act. He questioned the government's use of the word spouse. He questioned whether or not there was something sinister in the use of the word spouse as opposed to husband or wife. He even, sir, went so far, and the word spouse itself is gender neutral. It is. He even went so far as to say where spouse, where we all know in the interpretation act that spouse can refer to the masculine or the feminine. He said he would have been more comfortable if the legislation had instead said where a male spouse commits an offense against a female spouse, or a female spouse commits an offense against a male spouse. It happens, sir, to glance at the gallery where the consultants on legal drafting, the ones we rely on to draft our legislations, were over there. And I don't want to misinterpret the expression of the judge because he is wearing a mask. But I saw his eyes, and I'm sure there was a tear. But I definitely saw him cringe. Sir, I will speak slowly to allow the honourable member to be in a position to avail himself of some education, sir. The existing Sexual Offences Act, the existing one that we're amending, sir, in the interpretation section, which is section 2, actually the only thing in there that's interpreted, the only definition in that particular act in the interpretation section says, spouse means a lawful husband or wife, as the case may be. It means a lawful husband or wife, as the case may be. The problem, sir, comes in that when you actually got into the meat of the legislation, into the actual section, that is section 3, sir, it spoke about section 3.5. A husband who commits the offense of rape is liable on conviction or indictment to imprisonment for life. It defines spouse, but used husband. That created, sir, a confusion. When the legislation, when we were looking to draft the amendment to the legislation, and I can speak because I was involved in the drafting of it. When we were looking to draft the legislation, the definition of rape, as the honourable member pointed out over and over, the definition of rape no longer is the traditional rape. The traditional rape, sir, somebody thinks of a man introducing his penis into the vagina of somebody else. That was the definition of rape. That was rape all the time. So it didn't contemplate, sir, buggery. Buggery is an offense all of its own. It didn't contemplate buggery. It didn't contemplate anything else. The question was mooted for many years. What if the female in the relationship is the aggressor? What if the female perpetrates an act of violation against the male? It doesn't meet the standard of rape because a woman could not rape a man. We clarified that years ago by saying rape can't just be a penis. If you insert anything into an orifice, and they extended the orifices, it wasn't just vagina. Because if a male raped a female by vaginal penetration, and somebody else raped a female by anal penetration, it wasn't rape. Rape required the introduction into the vagina. I'm sorry to be so granular, sir, but it is necessary. The definition of rape was extended to include the violation of the vagina, the violation of the anus, the violation even of the mouth. If somebody sticks their male part into your mouth, it is rape. It is not forced oral intercourse. It is rape. You ain't getting permission to put it there. So, sir, we could not have spouse being defined as a husband or wife, and then having the offense of rape in the legislation only referring to where a husband does something and not where the wife does it. So if even we go to the anomalous, the situation where we even clarifying husband to wife, We are saying that now, everything a husband can be charged for, the wife can be charged for as well. However, when we look at the legislation, we actually saw something else. That while spouse refers to a husband or wife as the case may be, it does not take into account the definition of spouse in Barbados generally, which also includes unions other than marriage, spousal relationships. So someone in a union other than a marriage, where as far as Barbados is concerned, you are effectively married. You're not married in the church, you're not married in the court, but you, the woman, have all of the rights under the Succession Act and all other pieces of legislation as a married person. But under this legislation as it stood, the provisions in relation to rape didn't apply. All we did was clean that one up. It was determined that it was a nonsense to make provision for a husband to rape his wife or a wife to rape the husband and not make the same provision in a spousal relationship, which we otherwise accept as having the force of law in Barbados. So it is not, I sat down, sir, and listened to the Honourable Leader. I almost said him. I sat down and listened to the Honourable Leader of the opposition, sir, start to ride his horse off track. Then he started to gallop. And normally I would have stood up and tried to clarify. But I thought, when I do that, he takes offense. When I do that, instead of looking at the goodness of my heart to steering you on the right, the Honourable Leader of Opposition invariably takes offense and comes after me. I thought, you know what? Let him go along. Let him go along and say whatever he wants to say. Let him go along and put all his years of legal training into his address. Let him go along and put all of his research that he did into this piece of legislation on the table. And at the end of it, I will abandon everything else I have to say and come and deal with that, because I would then get the opportunity to speak unmolested, or so I thought. But to clear up for the avoidance of everybody, and I can actually, as I said, sir, sometimes you try to look into the minds of what the drafters were thinking. I can't speak for the future, but I can tell you that at the point of drafting that piece, there was no contemplation being given to any same-sex marriage, any change of legislation, any whatever. But I'll tell you, sir, one thing that did give me some cause of concern. And we as the government govern for everybody. We can't pick and choose who we want to govern for. What gave me some measure of concern, sir, was the venom being spewed by the Honourable Leader of the Opposition, that he hopes that this offense and protection apply to heterosexual couples and was not intended to apply to homosexual relationships. First of all, with the definition of rape, any person, also gender neutral, who does X, Y, or Z to another person, also gender neutral, without their consent, is guilty of rape. So they're already protected. Whoever he's seeking to exclude by this is already protected. But that was not even what bothered me. What bothered me was that you, the Honourable Leader of the Opposition, who hopes one day to lead this country, is starting by saying that he is picking and choosing who in this country should receive the protection of the law. Because if it is relating to a homosexual relationship, we want it out. That is what gave me the most pause. I don't have to agree with the way somebody lives their life. I don't have to agree with the choices they make. Quite frankly, sir, I don't agree with most things that the Honourable Leader of Opposition does or says. But let anybody come and tell me that he should be excluded, and this is, I'm saying he, the general he, should be excluded from the protection of the law because I don't like what he represents. I don't like who he is. I don't like what he stands for. I don't like how he dresses. I don't like how he behaves. Then I would attack that person on the behalf of the Honourable Leader of Opposition or whoever else somebody is seeking to deny the protection of the law to. That is the part that gave me the greatest pause and caused me concern. But I hope, sir, that having spoken thus far on that perhaps everybody is now on the same page. There's no subterfuge in here. When the government was forced to amend the legislation because of the ruling of Justice Michelle Weeks in a case, and that case, sir, quite frankly, it centered around what was serious indecency, what was gross indecency for the purpose of homosexual relationships. That's what it centered around. So it wasn't that we did it. The judge made a ruling. She made a ruling that serious indecency was too vague, that it is almost impossible to clearly define it. Serious indecency at that point in time, sir, was defined, 1 second, I think it was section 12, right?
Section 12.
An act of serious indecency is an act, whether natural or unnatural, by a person involving the use of the genital organs for the purpose of arousing or gratifying sexual desire. Well, sir, if anything begged for an explanation, it was that. And she rightly said it was too vague. You can't properly enforce this. You can't properly make a judgment on it. It was too vague. If it was too vague to use with two adults, it was too vague also to apply in the section with children. So she struck out the entire section. As the Honourable Leader of the Opposition said, it created a situation for us. Because that was the heaviest penalty you could get in relation to non-penetrative offenses against a child. Non-penetrative offenses against a child. That is the section for the rest of Barbados who needs to understand what are related to. If somebody troubled a child, or forced a child to trouble them, but it didn't amount to penetration, that was what you charged the person under. If you made a child perform oral sex on you, if you made a child masturbate you, if you masturbated the child but didn't cause any penetration, that was the section that you were charged under. The court said it was too vague. So we were left with a situation where you could still have sustained a charge against somebody who did those acts under sexual abuse, sexual assault. But it carried a lesser penalty than those. So we, recognizing that the judge has struck down these sections, and we said, you know what, quite frankly, we can't actually argue with that. We had to put something else in its place. It did not make sense to just go and address children. It did not make sense to just go and address Section 12 when a lot of other things in the legislation needed addressing at the same time. So we took the opportunity to plug all the, bad turn of phrase, but I'm already there. We took the opportunity to plug all the holes. We took the opportunity, sir, to correct all of the missteps, all of the things that were missing or didn't make sense in the legislation. For example, singling out a husband for rape when it should be a wife as well, and not acknowledging the fact that spouse was actually used to cover the definition of husband or wife. There are certain acts sort of have crept in to our culture. There's a grooming. We recognize, sir, across the world, children are groomed. A perpetrator, a pervert, would single out a child and say, you know what? Let me get there gently. I don't want to frighten the child. Let me build a trust. Let me get the child a sweetie. Let me befriend the child who is crying and put myself in a position that the child can rely on me. Let me get that child to trust me. And then let me start with gradual things. We accept that is there. We didn't have provision for it. In order to protect our children, we can't wait until the child has been abused. We had to look down, we had to look forward. What are all the steps now that we know lead to the abuse of children? Let us cut it at step 1. Obviously, sir, you can't, if somebody gives a child a sweetie or helps what a child wants, you can't read anything of that. But if that person seeks to do it a second time, and is showing their propensity to establish a pattern, then we have to step in to protect our children with the grooming. Grooming was never there. That's a major step. That's a big one. That's a big one for us. I congratulate the Attorney General for bringing that one in. But sir, we then look at pornography. We look at the reality of our situation. People trade in pictures of children, right? Adults are free with their cell phones, sir, to send a picture to whoever they want of whatever they want, if it's themselves. I can trade pictures, sir, with anybody. I wish, if I choose to do that, that's my business once the person's adult. But we then look at protecting children from, I guess, non-invasive abuse. If you circulate pictures of children, then we accept on the Computer Misuse Act, on all them things that you're doing wrong. And the defense always used to be publishing, if you're published. I didn't publish. If you circulate and send it to somebody else, that's where the offense was triggered. But we say it has to be more than that. You actually can't say, well, I have these pictures of a child on my phone or my computer. I ain't circulate them. So you can't really penalize me. No, you shouldn't have them at all. So we've taken the bold step, not just that you're circulated, not just that you're offering for sale, not just that you're transmitting. If you even have them, because there is no excuse. If even you are not sharing them with somebody else, you are actually using that child and those pictures for your own gratification, and that should be an offense. And we took the bold step to make that one an offense. The school is not yet finished. School is still in. We took the bold decision to go all out to protect our children. This is as cutting edge, sir, as it gets. This is as new as it gets. This is taking into consideration every single thing that we can. In relation, sir, coming off of the children, and I had indicated that when I was going to move away from addressing honorably the opposition, I would let the chairman know, so I'm off of him. No, sir. I can't speak to the presence or absence of anybody in the chamber. Sir, with the hearing in camera, the court should only hear the evidence of the complainant in camera. The court is only obliged to hear the evidence of the complainant in camera, but the court also has a discretion, sir, if something is prejudicial or the prejudicial value outweighs the probative value to actually make certain decisions. But why is that necessary? It is very difficult for a child. A child is treated differently in a court of law. You have to create a safe environment. It is hard enough for a child to relive a nightmare. I had a goddaughter, sir, who was afraid of clowns for some reason. And, you know, we always think that the best way to get somebody over there first is to expose them to it. So you buy a little comical plastic clown. And that child bawled and cried so much. But that was traumatic for a child. We didn't understand it. It seemed like a small thing for us. I had another goddaughter, sir, who was afraid of dogs. So I put a 6-day-old puppy with his eyes closed. I brought it to her to put it in her hand. And so if I didn't catch that puppy, she was traumatized by a 6-day-old puppy. So if a child can be thus traumatized by things, we have to understand that to relive an experience, it is hard enough to do it with a judge who's trying to speak to you in words that you might understand. It's hard enough to do it.
One thing you all remember.
No clowns, puppies, or children were hurt in the stories I just related, sir. But, sir, you cannot put that child or further a complainant, if they're not in a position to do it, to have to give the evidence in front of an entire courtroom, in front of a courtroom with persons watching, because criminal trials are open to the public. You can't make them do it with the reporters in there, with everybody watching you. That person will probably damage their own case, not because they can't give the evidence, but because they're so frightened and so traumatized by having to do it again. So you have fairness, sir, in a trial is not only fairness to the accused person, it also has to do with fairness to the victim or the complainant, right? And we have to create the environment for that. So I approve and appreciate, sir, the hearings in camera for taking the evidence of complainant, sir. The other thing, sir, the sexual communication with a minor, right? And causing a minor to watch sexual activities. Our focus before we did this was on the act, the sexual act itself, or some manifestation of a sexual act. We have expanded the reach and protection of this to be anything that is not appropriate for a child to see, feel, or experience. So you have no right to be showing a child pornography. There's no justification for it. You have no right to make a child watch you perform a sexual act. Or you have no right to masturbate in front of a child. All of these, sir, these protections are now clearly into this legislation. We have gone as far as we didn't just address the lacuna by striking down section 12. We went far to make this contemporary. Everything we can contemplate that might put a child in a position that it should not be in as a child, sir, we have looked to deal with and address in this legislation. Sir, we also have dealt with persons who may have the IQ of a child, persons with a mental disorder or physical disability. The existing legislation, I don't want to look for it now, I think the existing legislation mirrors what was in the Immigration Act, and it talked about idiots, imbeciles, feeble-minded persons, etc. That has no place in any piece of legislation in Barbados, right? We recognize mental health concerns, we realize mental health issues, we realize retarded development of persons. We recognize all those things, and the law must actually reflect those realities as well, sir. So, if you know somebody is suffering from a mental disorder, although the person may be over 18 or over the age of majority, if you know that person cannot really understand what they're doing, be in a position to consent to it, then you're committing an offense as well. So we're protecting, sir, not just children, but we're also protecting those who may be at the age of majority, right? But you know that they don't have the developmental capacity to actually understand what they're doing. We also, sir, the age of criminal responsibility for most, I think it's 12 years old. The age for children under this act was the age of consent is 16 years old. We had a number of different ages contending for what actually constituted a minor under this legislation. So we have clarified that one up entirely. The other thing that is retained, and we have to make allowances for certain things, sir. Usually before it was between 14 and 16 without their consent. You acknowledge that there was a space in there, sir, that there was an argument. I'm treading carefully because the legal position, sir, may not be the appropriate political position, but I'm treading carefully on it. The acknowledgement was that if a child was between 14 and 16 and was consenting, and you actually believed that they were over 16, then it couldn't be a sexual offense. There was some leeway in there.
Young man's defense, Honourable.
Correct, yes, sir. Right now, they've stripped that away. we've taken out the 14 in there, the reference of 14 is 16. 16 is the age of consent. Anybody under the age of consent can give consent. So it doesn't matter whether they were willing, we're not going to lessen the offense because they were willing. The law now says lucidly clearly that 16 is the cutoff age. If you are above 16, 16 and a day, or is it 16th birthday, you could do whatever you want. If you're below 16, you cannot consent. But they have retained in there the young man's defense. And the reason, because we had great debate over the retention of the young man's defense. It was not in the original drafted legislation, sir, but it was put back in. For those who are wondering what the young man's defense is, it says if the person is between 14 and 16 and you reasonably believed that they're above 16. So there's some people who look mature for the age. There's some persons who may actually try to fool you and present you with a false ID. There's somebody who may tell you, I am 18. If you have reasonable cause to believe, I understand, sir, it is reasonable cause to believe, because if you go and pick up a school child in junior school uniform, and the child telling you they're 17 years old, you gotta ask yourself some questions while you're there, right? If you have reasonable cause to believe that the child was between 14, the child was over 16, and they were between 14 and 16, and you were under the age of 24. I don't know what case made it the age of 24, but you, the person, have to be under the age of 24, technically still a young person. Then you may have a defense to rape, to statutory rape, to rape. But there's a caveat. You can only use that defense once. If you have cause to use that defense a second time, the court is of the opinion where you didn't learn. You took somebody borderline the first time, you got off from it, and you went back again, then you're not serious. So, sir, all the protections that existed before, I know that we are well into lunch. All the protections, sir, that existed before are still in. The anomalies, sir, the gray areas have been clarified. The area in relation to spouse and husband vis-a-vis rape and where the rape is applicable, that has been clarified. The fact that it applies now to spousal relationships has been clarified. There was no need to put male spouse against female spouse and female spouse against male spouse. Sir, that is a legislative nonsense. That has been clarified in here on the floor of Parliament to those who expressed the concern. The issue in relation to corroboration, I believe, sir, has been clarified. To all who have ears and wish to hear, they now know. So I wish, sir, to thank the Honourable Attorney General and those who were instrumental, sir, in drafting the legislation and taking the opportunity to draft the legislation and correct not just the issue of striking down of Section 12, but all the other things that appear to us to be in need of addressing at the same time. I just want to leave this one thing, sir. While people talked about Section 12 and that we left children unprotected, it was not that children were unprotected, because any offense against a child could still be brought under one of the other sections of the legislation, sexual assault, but the penalty would have been less. So we accepted that the penalty, it created a situation where the higher penalty was for the gross indecency and serious indecency. And we needed to put a provision in there that kept it as serious or made it even more serious than it was at the time when the section was struck down. So this does that. So the penalties range up to life in certain aspects. So the only issue that I can actually see, sir, is some lawyers saying, well, you did away with the warning, which is going to make our life even more difficult. But a skilled lawyer, sir, will be able to cover that some other way and address that in his wrap-up. So there's no prejudice to anybody, but persons are greater protected under this piece of legislation, under these amendments, than they were before. So I, sir, in light of all of that, have no difficulty at all and firmly recommend this legislation and support it entirely. Thank you, sir.
Honourable Leader of Government Business. question is that this honorable chamber be suspended until 3 p.m. All those honorable members in favor, please say aye. Those against, please say no. Meeting, the ayes have it. This chamber stands suspended until 3 p.m.